Good morning, everyone, and welcome. I am Jason Mozo, the Executive Director for the Florida Chamber Safety Council, and I want to thank all of you for taking the time and joining us this morning. Today's webinar is focused on OSHA's recently updated record-keeping requirements. Leading the webinar, we have Ed Falk, former head of OSHA and member of the Florida Chamber Leadership Cabinet Advisory Board. We hope you will walk away with understanding the new record-keeping updates for all employers, as well as how you can effectively use record keeping to improve your current safety and health management programs. The Florida Chamber Safety Council was launched in the summer of 2020 with the mission of making Florida the safest, healthiest, and most sustainable state in America. We are grateful to Ed and our advisory board of leading statewide companies for providing us with the best practices and helping to make Florida a national model for workplace safety. To accomplish this, Florida businesses and their employees need access to high-quality educational webinars focused on workplace safety. Here on your screen, you'll see just a sample of some of the customized on-site trainings that we offer. Our trainers are fully certified and qualified experts in their respective fields of safety and health, and our team will come to you to conduct these trainings at your site at no additional costs. In addition to our private training courses, we also offer public training courses, which are unique safety trainings for safety professionals as well as human resource professionals that can take conveniently from home or work with our virtual offerings. Please visit our website at flchambersafety.com/learn to learn more about these courses and register for any classes that you are interested in. We are thrilled to offer additional public safety courses at our 2024 Leadership Conference on Safety, Health, and Sustainability on May 8th. They are the perfect opportunity for professional development for you and your team before attending our conference. Exhibitor registration is now open for our Leadership Conference. This year, we have made some changes and some updates to make it a much better experience. These booths include premium booth placements, lead retrieval apps, access to attendee list, and learning labs that is designed to provide you time with the conference attendees. So if you are interested in exhibiting, please reach out to me and I can get you more information on that. The early bird registration is still going on for the 2024 Leadership Conference on Safety, Health, and Sustainability, and we are thrilled to welcome 23-time Olympic gold medalist and mental health advocate Michael Phelps as our opening keynote speaker. This conference is the nation's only event of its kind that is dedicated to helping you and your company move the needle on safety, health, and sustainability. It is the premier event for Florida leaders who are ready to learn how to affect lasting excellence in the three pillars that are essential to workplace success. We invite you to visit our conference website and take advantage of discounted registration rates now through February 14th. Last year, we launched a new membership program for the Florida Chamber Safety Council. We know how difficult it could be for an HR director or head of operations that has to juggle safety for the business, which is why the Florida Chamber Safety Council wants to serve as your safety department and partner in staying compliant and keeping your teams safe. You can choose from 3 different membership levels: Safety Champion, Safety Leader, and Safety Advocate. Each level includes 24/7 safety support, a Safety Council orientation, and a complete annual risk evaluation of your business and your safety and health programs. Then, based on your level of choice, you can choose from a list of safety training classes that can be taken either in person or virtually. You will also always receive a discount on any additional safety trainings that you are interested in scheduling. Please be sure to check out more on our website and reach out to me directly if you feel that this membership program is right for you. As we continue growing and expanding our services, the Florida Chamber Safety Council is partnering with national leading companies providing high-quality safety supplies. We are here as a resource to better provide you with supplies and solutions to establish a healthier and safer workplace. If there is anything that you may need and or have questions regarding providing certain safety supplies and solutions to your employees, please do not hesitate to contact me at any time. Without further ado, it is my pleasure and honor to turn the program over to Florida Chamber Leadership Cabinet member Ed Falk. Ed is the only attorney in the country that is confirmed by the United States Senate to run OSHA. He is currently a partner at Fisher Phillips and also serves as president of Fisher Phillips Safety Solutions, LLC. Prior to joining Fisher Phillips, Ed was the Assistant Secretary of Labor for the Occupational Safety and Health named by President George W. Bush, serving from April 2006 to November 2008. During his tenure at OSHA, workplace injuries, illnesses, and fatality rates dropped to their lowest levels in recorded history. For more than 30 years, Ed has worked in the labor and employment area, focusing on occupational safety and health issues, workplace violence risk assessments and prevention, whistleblower protection, and accident and fatality prevention. He is recognized as one of the nation's leading authorities on occupational safety and health, and is a frequent keynote speaker and lecturer on workplace safety, leadership development, and other labor and employment topics. Ed, can't thank you enough for lending your time and talent to us today. The floor is yours, my friend. Oh, you're on mute, Ed.
All right, there we go. Can you? All right, yeah, thank you, Jason. I appreciate the intro. And without further ado, what does ado mean? I never can figure that. I thought about that. Anyway, we're going to keep moving along here. I want to thank everybody that's on here today. To the fact that you're here, I think demonstrates you have a strong commitment to safety and health, and you want to make sure that your employees are safe and sound. So that's why I want to just start off by that. I put this. I saw this quote by Vince Lombardi. Winning is not a sometimes thing; it's an all times thing. And when I saw that, I said, my God, that's exactly what safety is all about. Safety has to be an all times thing, not the thing. So thank you for your commitment, the fact that you're here doing all this. And this is a very important program. I mean, I know you probably hear that from every speaker that you see, but it really is important, because record keeping, OSHA is really focused now more on record keeping than it ever has. And the things that have been recently done, the changes that they made to the reporting, electronic reporting requirements for employers has really dramatically changed the landscape, and can and really dramatically impact your company from several different standpoints, but particularly the impact that it could have on notifying. This information that you're going to be providing. We'll talk a little bit in a minute about these different requirements on reporting, either or electronically filing, either just the 300-day summary, which pretty much covers almost everybody, but not everybody. But the other one, the new one, the biggest new one, now covers anyone over 100 on 100 employees or more on a particular industry, designated industries, what they consider high hazard industries, which covers a lot of employers, unfortunately. Is going to be expanding that to your requirements to reporting this information. And the information you're going to be providing, unfortunately, is going to be used by outside third parties, and that could dramatically impact from a negative standpoint your company. So, but let's just talk a little why it's important. The broader definition of recordable injuries and illnesses, that's what I was kind of talking about there. Better tracking on occupational safety and health, accompanied by emphasis on industrial hygiene regulations. So you're seeing more of this. The concept expanded, basically what is work related, has really been kind of moved. Limited the definition of first aid. So if it's not first aid, then it's medical treatment. And if it's medical treatment, then it's going to be recorded on the your OSHA 300 logs, and then show up on your OSHA 300-day summaries on that. So that's why we need to be. That's why this is important. Of course, OSHA has been raising the average penalty over the last, oh God, now it's been 4, 5, 6, 7, about 8 or 9 years. They have really continued to expand the penalty amount. there was a change by the Congress in a budget bill of all things, and they've never actually changed the act. So technically, if you look at it, it says $70,000 is the maximum penalty you could charge, but that's not the case anymore because we're all way up at the for a willful violation or a repeat violation. We're going to be looking at was it $46,000 because of potential high penalty. So it's a lot there to do that. So if you're an employee of multiple locations, that requires certain information, or it's going to make it a little more difficult as to breaking out the information. Make sure you're properly reporting it to the proper facility, or what OSHA calls is establishment. So we always have to remember that when we're talking here, we're talking every one of your facilities is a separate establishment, unless they're kind of joint, unless they're in the same block or same 2 blocks, maybe you might be able to argue that, but other than that, so. But you can see the new coverage on the reporting requirements. And when we talk about reporting, this is where you, as the employer, have to notify OSHA of these particular things. If you have a fatality, then you have to, if you have a workplace, you have a work-related fatality. Now, very important, I say work-related, you need to understand that. And the same thing with hospitalization, or all these things actually, but particularly fatalities. You have to look and see, is it a work-related fatality? And if you have a work-related fatality, then you, the employer, and this is even for those employers that are exempt, and we'll talk a little bit about that shortly. I'll actually show you the list there. There are certain employees that are partially exempt, and when they say partially exempt, it means you don't have to do the 300 logs or the 300A summaries, but it doesn't exempt you from the reporting requirements of calling in OSHA. So if you have a work-related fatality, you have 8 hours to contact OSHA once you become aware of the fatality. That gives you a little bit of flexibility, but not a whole lot, to be quite honest. And to be quite honest, also, if you have a work-related fatality, a person goes to the hospital, or the coroner is brought in, more than likely the hospital, the EMTs, the coroner is going to call OSHA and advise them of this accident and the fatality. So you're going to pretty much, so you may have 8 hours, but more than likely OSHA is going to show up maybe even sooner than that. So you need to be aware of that. So you have that 8 hours. Then, and this is, they are citing employers for failure to meet the 8-hour rule. So if you have a work-related hospitalization or an amputation or a loss of an eye, and now let me caution too, the amputation, OSHA's interpretation of an amputation is a loss of a fingertip or something like that. You don't have to have any bone loss. You don't have to lose the whole finger. You don't need to lose the foot or the hand or whatever. If you lose your fingertip, that is considered an amputation. And note this thing on hospitalization. Hospitalization, what OSHA interprets that to mean is that the person is actually admitted into the hospital. He's not just in the ER and then sent home, because that's not considered a hospitalization. But if he stays in the hospitalization, if he stays in the hospital and is actually admitted into the hospital, that's a hospitalization. And you have, on all 3 of these, you have 24 hours to call OSHA and advise them. Now, under the standard, it specifically spells out on all 4 of these things the information that you need to provide. But basically, what they're going to want to ask, what you're going to get asked, or if you leave a voice message on the voice recorder, it's going to tell you what you're supposed to be leaving. You're supposed to call and notify, give them your name, company's name, company location of where the accident occurred or the fatality occurred, the time and date that it occurred, and then your information of who you are, your address, your contact information, and then they're going to ask you what happened and give a brief description of what happened. So, and it's very important that when you're reporting these things, either if you're leaving a message, or if more importantly, if you're actually talking to an OSHA person, you want to kind of limit that information that you're providing them to just the facts. Okay, don't go into a big deal. if a person, is hospitalized for a cut, you don't want to say, well, the employee was hospitalized and just leave it like that. You really kind of want to give a little bit more information, because depending on what information you provide will determine whether or not OSHA is going to come out and do an inspection. So you need to be thinking about that if it's a hospitalization. You need to say, well, the employee was hospitalized. He had a cut on his hand. He was admitted to the hospital, but they were just doing that for observation purposes. Because person admitted to the hospital for observation is not hospitalization under OSHA's rules. So you need to be able to make sure that make it sound like he was just admitted there. Now, if it was, you need to know that it means ask the hospital, was he actually admitted, first of all, and what was the person keeping him there? Unfortunately, most of the time, if somebody's admitted to the hospital overnight, particularly, they're going to get some type of medication, and that's going to make it reportable anyway, and then reportable also. So, but so you just need to understand that these type of things. That's what they're going. But you have 24 hours if you have a work-related hospitalization, amputation, loss of an eye. And I've been doing this for a really long time. I've never had a loss of an eye, a case where loss of an eye. So anyway, of course, then they also added the stuff in December of 2016 and about retaliation, and we'll talk a little bit more about that. And then we're going to talk a lot more about the electronic filing. And then this year they expanded the electronic filing, so you need to realize this is something that can actually impact you pretty dramatically. OSHA's looked at the temporary worker initiative, trying to decide whether, are you the employer versus whoever the temp service is. And the part of the problems, and I get a lot of clients call me up or send me. I get a lot of clients doing inspections. So you get one of the things OSHA is going to ask for is your 300 logs. They're going to ask. Usually they just ask for just 3. You are required under the regulation to keep the last 5 years plus the current year of 300 logs and the 300-day summaries. Of course, you wouldn't have a 300-day summary for 2024 because it's not. You have to go through the whole year. So, but you would be shocked how many times during an inspection OSHA asks for these things, and I tell to my client, please send me the 300 logs and the 300-day summaries before you send it to OSHA, and I'll look at it. And it's amazing how many even large Fortune 500 companies are doing these things wrong. And you don't want it to do wrong, because if you're putting more, if you're including more, incidents on your logs, that's going to make you look bad. The more incidents you have, it means that more that people are going to be able to focus are going to focus on saying, "Oh, this is a bad employer," because look how many entries on the 300 logs they have. So you want to make that. So you have a lot of employers recording first aid incidents. First aid is not recordable, okay? And we'll talk about that. What is actually first aid? And if it's not first aid, it's automatically medical treatment, okay? That was one of the things OSHA really did, was to limit what was actually a first aid incident. And a lot of times you have here no coordination between workers' comp and OSHA record keeping. So you want to be able, if you're doing OSHA record keeping, you need to know if it's a workers' comp case, more than likely it's going to go on the log. Now, if it's recordable on the log, that does not necessarily mean it's a workers' comp case. All right. So there's a little distinction there you need to be aware of. And then you have problems where employers are not auditing it or correcting the documents when they find out there's different numbers. And we'll talk a little bit about that also, but specifically on your 300 logs, if somebody's out for, lost time and he or she's had a serious accident and is going to be out for, several months, your responsibility is to first try to ascertain how long you think that person's going to be out and use that number as a marker. And then when they finally return, then you actually put the actual number in there. So you want to be able to do that. But if you're not coordinating with your workers' comp people, your numbers are probably going to be upside down, or at least not correct. You're going to be off somewhere. So injury records are used sometimes to drive employee safety program, but that was not what it was ever intended to do. I mean, you really want to have a good safety program because it's the right thing to do. And also safety can be a profit center for a company, for every company. So, and then you hear this last one. This is one of the big ones too. More employers are selecting contractors, suppliers, and vendors in part based on their injury and illness records. They're using organizations like ISN and ABETA. Those are the two largest. They're what I call contractor certifiers. And what they're doing is they're going to ask to see your 300 logs and information, and that's how they rate you. And if you don't get a good rating, guess what? You may not be able to bid on the projects because the client that hires ISN or ABETA has set up certain parameters, and those parameters vary from different from employer to employer. But so you could be potentially barred from being able to bid on any projects or get work because of your injury and illness and your lockout. Excuse me, your 300 logs and the 300-day summaries. That information could really hurt you if it's not done. That's why I'm saying we got to make sure when we're doing these things, we're doing them right. Because to be quite honest, my what I've experienced over these a long time period, I've experienced it's more likely that the employer is going to over-report than under-report. Okay, there's some under-reporting, but most of the time it's over-reporting, and therefore now you've made your numbers look good because from your 300 days, you can do your injury and illness rates, you can do your DART rates. So, and then from that, they can compare that to the industry average, and you can see how that could hurt you. So you want to make sure that you're recording on the 300 logs and the 300-day summaries. You want that you're recording the proper information, the cases that are actually truly reportable, okay, or recordable, excuse me. And so, because if you over-report, that just hurts you. It makes your numbers, your injury and illness rates go up, your DART rates go up. It just makes you look bad. So that's one of the most things we're going to be talking about here is that you're properly entering the data that needs to go in there, but not stuff that's not supposed to be in there. So, and we'll get into them a little bit more. Okay, so what are we going to do going forward? Well, we're going to make sure we have we're going to try to develop measures that are for our safety and health program that are more geared to what we call leading indicators versus active leading indicators versus looking at measurements that look on all data, things that have happened. I mean, if you're looking at your 300 logs, that's things that have already happened. You can't change that. So you want to make sure you're making that your focus on your safety program is to be utilizing leading indicators versus lagging indicators. And because the lagging indicators have already happened and you can't correct it. So you want to get that. You want to make sure you see your safety programs, make sure we're not focused on lagging indicators. In other words, once again, entries on the logs. And of course, you want to have a plan in place how to handle OSHA record keeping inspection, because that can take a lot of time. And if they come in and do an inspection, those inspections usually involve 2 or 3 inspectors and usually last 2 or 3 weeks. So if you've got 3 inspectors there that last 3 weeks, you're talking about a lot of time being spent by your management people just to be handling the record keeping inspection. So that's why it's important. You want to make sure you keep updating everything that you have with respect to record keeping. So, you want to make sure you're going to audit your record keeping process. And that's because you want to focus on, what does OSHA require? What's the difference between first aid and family medical leave? Because those do not necessarily are not necessarily being going to cover through the record keeping process. Workers' comp is important because that can tell you what information about how long that person's off, how many they've been out on that. And also, you should also be looking at the short-term and long-term disability information to be able to fill out properly your logs. Now, looking at first aid, and the family medical leave, but first aid particularly, um, that may not be covered. You got to make that determination. Is this really a first aid incident, or is it medical treatment? And how can I make a distinction on that when I'm putting my records together, when I'm actually reporting this stuff or recording this stuff on the 300 logs? So one of the things you want to try to do is consolidate as much as you can injury and illness record keeping into one system. So, if you have one person that's responsible for the OSHA 300 logs and the 300-day summaries, then perhaps you also need to be having them tied in somehow to the company's workers' comp program and stuff, so they can know exactly, what exactly going on under that particular. So, and you can, if you can have a corporate wide log in some cases. Normally, it's involved with a small company that maybe has one other facility or something like that. But you need to be a little bit careful about that. But you want to make sure that the information is getting to the right persons when you have that situation, particularly from getting information from the other facilities getting maintained on the log itself. And of course, we're going to look at our collection procedures and how we're entering this data electronically on the site, so we can make sure keep up with everything there. You need to self-audit logs for 5 years. Like I said, you are required under the record keeping standard to keep current 5 years, the past 5 years logs, 300-day summaries, 301s or first report of injury forms for 5 years plus the current one. Okay. Now, under the record keeping standard itself, you are required to update your logs, particularly with respect to lost time or restricted work or those basically are the two main ones. You're supposed to continually update that during that 5-year period because you're required to do that. So, and then what happens is, though, you make the changes, you update the 300 logs, but you don't update the 300-day summaries, because once you make a change on the 300 logs, you've made there's now the information that's on the 300-day summary is different, okay, and now incorrect. So you need to be aware of that there. So you need to be auditing that process there. Make sure that they're being made properly. So, all right. If you're living in if your operations are in a state plan state, and there's about 20 of those around the country, then for the most part, the state plan states they've adopted the OSHA record keeping standard verbatim. But there is some states, and I'm trying to remember right offhand, that do have some different requirements on providing information. So you need to look on that. And of course, OSHA has been very much focused on musculoskeletal disorders there. And their big thing last several years, they've been really focused on heat stress, obviously, workplace violence, and then musculoskeletal and ergonomics problems. So we need to be aware of that, because they're going to be looking at that. And if you have strains or something like that, and you need to make sure that those are getting on the board, or should be getting on the log, because they're because they're required. So that. So all right. Electronic filing and whistleblower rotation. What they did on the whistleblowers, they actually expanded that to they're looking at that and see if you're requiring your employees to report injuries and illnesses, work-related injuries and illnesses, immediately, then and they don't do it, and you sometimes discipline people for not doing that. That OSHA would consider that as it's kind of a retaliation provision, and therefore you could get a citation or a violation of the whistleblower standard. It would be a citation; it would be a violation, which could have some type of monetary penalty too. So you need to be on that too. And of course, back as I mentioned earlier, in 2017, they talked about the electronic filing requirements. And this came in during the Obama administration. And then, and what that was that you, on the requirements there, basically it said that you're going to have to, if you have so many employees and you're in certain industries, then you're going to have to report, not only submit your 300A summaries, but also your 300 logs and your 301s, which is basically your workers' comp form, or if you have your own form. A lot of companies use their own form, but now you're going to have to do that. Well, so that was during the Obama administration. Well, but Trump withdrew most of that, in that it said, well, we're going to still require you to file your 300-day summaries on March 2nd. Well, it changed differently, but I think this year is March 2nd. And then the Trump administration came in and said, no, we're not going to require you to submit your 300 days, or submit your 300 logs and your 301s, or first report of injury forms. But we will have you continue to electronically file your 300-day summaries. Well, in the Biden administration now, that they kind of, with Obama put it in, Trump pulled it out, Obama's now put it in again. So it's now in place, and you need to be aware of that come March 2nd, you need to, if you're in that certain industries, and we're going to be including there, I think we have it listed as a handout 1. All right, but basically it's this form here we got. Let me pull it up here. You can see it's hard to see, but it's going to say, where is it? That was it. 100 is if you have 100 employees in your certain industries, you're going to have to file all 3 of them. So, we'll talk a little bit more about that in a second, but you just need to be aware of that. So, I don't know what this is. I don't see that. I don't know where that some slide came from, but anyway, all right. What must I do? Under the record keeping standard, you are required to put a how employees are to report. You're supposed to have a procedure in place for them to report promptly and accurately. And you can't have a procedure that it would not be reasonable if it would deter or discourage employees from accurately reporting workplace injuries or illnesses. So, if you're telling people that they have to report any accidents or any injuries or any property damage, immediately, OSHA would consider that a little not reasonable. So it's important that when if you have a policy like it should be saying, as soon as reasonably possible, but not later than the next day or 2 days or 3 days. Some companies have 3 days, that you have to report this information if you've had an accident, a work-related injury, or some type of property damage. So, because if you don't give it that extension, if you don't give it that kind of make it easier to a certain, if you say as soon as reasonably possible, as soon as you say as soon as reasonably possible, now that makes it reasonable. So you want to have that. So you need to look at your reporting requirements of injuries or accidents that you have for work-related incidents, so that you are allowing some flexibility there, because OSHA will look at that as they're going through this things about record keeping. They're going to just be saying, okay, we'll cite you for that because we see you're not following what we request there. So you want to be reasonable, give them an opportunity, but you can set the time period. You can say, if you need to report injuries, illnesses, or fatalities, or accidents as soon as reasonably possible, but no later than 3 days from the time of the occurrence. That would be considered reasonable, and OSHA wouldn't cite you on that. So you need to be aware of that too. If you have incentive programs, we reward people for experiencing no reportable work-related injuries. OSHA is going to consider that to be an incentive not to report, and which would be a violation, because what happens is that some people may not report, but the person that reports, he or she does not get the incentive or the reward. And therefore, now you've retaliated against that person for not reporting a work-related injury or illness. And so you discriminated against them, and that would be considered a whistleblower violation, because he or she's not reporting it because he wants to get, or she wants to get the $100 gift card for not having an accident in the last 6 months. So you once again, you see here, you want to emphasize that 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 they don't have to report it immediately. They do have some flexibility there, but they do have to report it. I mean, we need to know if somebody's injured. We need to know for a couple of reasons. First of all, we want to make sure that they get their treatment. They want to make sure that they're getting whatever they need to get the medical treatment they need to get to be able to recover, fully recover. And secondly, if we don't get it reported very quickly, then sometimes our workers' comp carriers start talking about that, don't want to cover it because it wasn't processed when it should have been. So, and also if you have a workplace workplace safety incentive programs, OSHA is going to be looking to see, do you give them some flexibility? You know, is there, and also they're going to look and see if you're drug testing people, but only when they have an accident that has some type of injury or property damage. They're going to say, well, now you're discriminating against those people versus the people that may have other accidents that they don't have to. So you need to be a little bit careful about that more. This is not as they are really focused on this several years ago. Actually, more so, I guess, was in the Obama administration. But and Trump, it kind of went dormant, and then now you're starting to see another push for it in the Biden administration. So you're going to have to strike an appropriate balance, limit the instance of testing the situations where there, it's likely there's some type of likelihood that the drug use of drugs or something may have been part of the cause of the impairment. So we need to do that. So you got to be looking at that. Part of that means that you're going to be training your supervisors as to be able to observe, signs of drug use or a drug impairment on the work site. This is very important. Now, people say, well, I don't know if I want to do that, but well, it's important that you want people to be able to, your supervisors to be able to identify impairment caused by drug use. Now, drug testing, that becomes a little problematic because, if they're using marijuana, if they used it before they got there, they still could be impaired, but they're not going to have a test that's going to tell you how impaired they are. So you're going to be a little bit careful about that. So, all right, let's keep going here because we got a bunch of other things here. So look this thing here. This is really the test. I think it. Well, whether the employee had a reasonable basis to believe that drug use by the reporting employee could have contributed to the injury or illness. So, and the only way you're going to be able to have that reasonable basis is that you're training your supervisors on to observe and know when there is some type of drug impairment. So, all right. So we talked about moving the word immediate from your injury reporting policy. Move away from incentivizing using lagging indicators, i.e., not having an injury. That would be a lagging indicator. What you could move to, obviously, is that they are attending all the safety meetings that are put on by the company, or something like that, which would be more of a leading indicator there. So. I think we got that. We've already covered all that there. So, all right. So we're going to kind of talk about partial exemption. This was one of the things I wanted. We kind of trying to start on, but I mentioned it briefly earlier. You're going to have a handout. It's going to be marked handout 1, I believe. I'm looking at it, but I don't see it marked as handout 1. But it basically says it says in the heading there, partially exempt industries. Now, if you're on this list, then and there's 80 different, I think there's 81 industries that are on the exempt list. If you're on this list, you do not have to maintain the OSHA 300 logs, the 301s, or the 300A summaries. There's no requirement on that. I have a number of clients that have that, which makes them very happy. Although every time OSHA comes in to them, they always ask them immediately, we want to see your 300 logs, and then we have to go explain to them that they are on the partially exempt industries. Now, what this means about partially exempt is that you're exempt from having to do the 300 logs, 300-day summaries, or 301s. Unless you get a letter, usually it's sometime in March, February, March, where OSHA or Bureau of Labor Statistics, BLS, sends you a letter saying, we will, for this year, for 2024, we want you to maintain your 300 days, 300 logs, and record that information. And at the end of the year, have a 300-day summary. So if you get asked to do that, then you are required to do that. You are required, if you're asked by OSHA, or if you're asked by Bureau of Labor Statistics, BLS, then you must, even though you're on this list of partially exempt industries, you still have to do it for that year, but just that year. The list, though, what this does is you are partially exempt from doing the record keeping, actually physical logs, but you are not exempt from contacting OSHA, reporting to OSHA any fatalities, work-related hospitalizations, work-related amputations, work-related loss of an eye. You still have to do those, meet that requirement, and report those within the time periods, the 8 hours for fatalities, 24 hours for the others. So you need to be aware of that and just know that that's what the partial exempt list is. It only exempts you from doing the record keeping, the reporting stuff there. So, all right, let's keep moving on. So we want to keep going here. So if your company has 10 or fewer employees at all times during the last calendar year, you do not need to keep the injury and illness records. Once again, unless you've been asked by OSHA or BLS to do that. So so here, 10 or fewer people, that's the size exempt. Now, note what that second bullet says. Size exemption is based on the number of employees in the entire company. So that doesn't cover, like, fortunately, that leaves a lot of employers covered under the standard. So under this, and so the number of employers that have less than 10 or fewer employees company wide is very few, and so that's why there's very few people that can say that they're under exempt from the reporting. So, all right, let's keep going here. I gotta get that fast. All right, so and these are the reporting requirements. Once again, we're talking about contacting OSHA, either calling them at the area office or going online. Use the 800 number. You can do all three, one of those three. So if you have establishments, and once again, establishment is one facility. Okay. So if you have establishment with 20 employees up to 249 employees in a classified industry listed in Appendix A, handout number 2, then you must file with OSHA the 300-day summaries by March 2nd, the 300-day summaries. Now, that covers a lot of employers, to be quite honest. It's several, about a page and a half long of different companies. But but the problem is for employers is you're talking about. Let me just read a couple of people that have fallen under this particular handout B. Handout, you got utilities, construction, manufacturing, wholesale trade, automotive, grocery stores, department stores, vending, taxi services, warehouse and storage, cable, real estate. So you're talking about a lot of building services, the building, waste collection, amusements, gambling, travel, all these things. You got a lot of different large industries that if you have 20 employees for that facility, up to 249. I'm looking at 249 cells. Then you have to file your OSHA 300-day summaries on March 2nd. All right, so that will be handout number 2 that you'll see. Then look in the next one. Establishments with 100 or more employees in designated industries, and this is the third one, handout number 3. And it's going to say, where is it? Where it is? Designated for annual electronic submission of information for 300 logs, 301s, and first report of injuries. So, your first report of excuse me, the first one was 301s, and your 300-day summary. 300-day summaries are going to be caught up in the other one. So you're going to see this one here. If you're in this group, this means you're going to have to file 300 logs, 301s, which is the supporting data for each entry on the log. And then, of course, you're going to have to also provide the 300-day summary. But why this is important, I mentioned this at the beginning of the talk here. Why this is important, because you're going to have this information you're going to electronically file this with OSHA by March 3rd or 2nd. Please don't wait till March 2nd, because you're going to find out when you do that, the system has a bad habit of crashing because everybody and their brother is trying to get on the last day. So try to do it in advance, a week or 2 weeks. But what is my concern, and this was kind of what was in the Obama administration, and then Trump didn't do the whole thing. It just did the 301s or 300 days. What this means is this information is going to be electronically transferred to OSHA, who will then put it on the OSHA website, all right, and make it available to different groups like unions or plaintiffs' lawyers or community activists, anybody who might be upset with you or want to file a lawsuit against you. You know, the unions are going to use this information to be able to say, hey, look how bad this company is. Look at all the injuries and illnesses they have, particularly injuries. They don't care about you from a safety standpoint. That's what there's going to be. Same thing with the plaintiffs' lawyers. They're looking to be able to bring lawsuits against companies for injuries, and they're going to be monitoring this information and looking. They're going to have their list of companies they want to target. Probably, and of course, they're going to probably have deep pockets. And you want to make sure. This is why you want to make sure that the information you're putting on the 300 logs is the information that's supposed to go on it, that it actually is recorded. And we're going to get into how to make sure on that. But this is critical. You're going to see a lot of people using this stuff to go after companies. And so I'm just saying that please pay attention to what you're putting on the logs. And because when you have the 300 logs, well, actually, if you have the 300-day summaries, you can pretty much determine what the company's injury and illness rate is and the DART rate is. Well, and then they're going to be able to compare that to what the industry average is. So they're going to be going after this. So you can use this thing as and particularly the unions. I used to do some OSHA work, actually some NLRB work, early on when I first started practicing law. And one of the things that was true then is true today, is that if the unions can make safety the number one issue in the union election, that is their highest win rate, something like 65% win rate, if they can make safety the primary issue in the union campaign. And so they use this data, they're going to be able to use this data to say, look how bad this company is, look how many people have gotten injured. The plaintiffs' lawyers are going to take that information and try to determine who was the people that were injured, and let's bring lawsuits against the company, even though there's workers' comp. You know, there's states, and there's at least one state, and I don't know which one it is. I keep forgetting which one it is. It's what happens when you get old. But there's one that you can get workers' comp, and then you can sue in tort against your employer. So, which is kind of screwy, because the whole purpose of workers' comp was to provide a quick payment out for employees that got injured on the job, but limit the liability for employers. Well, now you've kind of got rid of that whole thing, which is kind of interesting. But anyway, all right. So here's what we're going to kind of go through the rest of the program. And we got, what time is it here? No, I don't see. But anyway, I'll figure it out. But so we got over half. We got about 40 minutes or so. These are the ones we're going to cover. These different things we're going to cover, but it's important. Once again, and when you have any questions, you're going to be able to, please put those on the chat screen, the Q&A screen. So we'll get to those. If I don't get to them, I'll make sure you get an answer somehow. Who's responsible for recording? Actually, employers actually supervising the employee is typically required to do the injury and illness. Some more temporary providers, so most temp providers do not do 300 logs. Okay, you more than likely, if you're supervising a temp person, he or she's going on your 300 log. Okay, there's no, it's just that straightforward. So now, if you're an independent contractor, then you're not an employee, and then you don't go on the logs. Okay. Now the problem is, I don't know if you saw this yesterday, but OSHA put out its final rules on employees, independent contractors, and employees, how the classification of them. The purpose of this was intended to have less independent contractors and more people classified as employees. Now that means, because if you're an independent contractor, you're not covered by OSHA. So OSHA wanted, it was a twofold, several things probably, but the first thing is OSHA wanted to make sure that the more people were covered under the act, that they were actually employees. So that's why they made it more difficult to say that you're an independent contractor. And then from a union standpoint, they want more people to be employees versus, because they don't organize independent contractors. So but that's kind of why a lot of this goes on. You got to understand where things go from, where it's coming from. So if you're going to determine whether or not you're recording something, you have to make these determinations. Is it work related? If it's not work related, it doesn't go on the log. It's not recordable. Is it a new case? Well, if you have another, let's say last year somebody had an accident and you put it on the log in 2023, but they're still out, then that, it's not a new case. It goes back to, it goes on through 2023 logs. Okay, you just keep adding it up until you get to 180, and we'll talk about that in a minute. So, but if you don't have another case already open on it, another thing on that particular injury, work-related injury, then it's a new case. Then does it cover one or more of the criteria through these sections, and we're going to go through each one of them. But basically, it's going to be looking at the, is it fatality? Was there hospitalization? Was there restricted work? Was there lost time work? Was there medical treatment? Those are the things you're going to think. We'll see. We're going to go through that. So let's keep going, because we got a good bit to do yet. So here's kind of the flow chart. Did the employee experience injury? Yes. If it's no, then and it should say, well, the next one, is it work related? Well, we're going to have a lot of people may have injuries that are not work related. So, but we have to say yes, they need to continue on it. Is it a new case? No, or yes. In most cases, it's yes. Because if it's an old case, then you got to just go back, and you're not putting it on the log, a different spot. You're just updating the numbers. Does it need to meet the general criteria and application for a specific case? And, once again, that's going to be, is there a fatality, lost time, restricted work, medical treatment, those type of things. So that's how we know. This is how we go determine whether or not it's going on the 300 log. So look at this definition of injury or illness: abnormal condition or disorder. Lord knows, is that you could drive a tractor trailer through that one. It's so broad. So you want to make sure. But it's not, look at it, it's not limited to cuts, fractures, sprains. This is the definition that's in the standard itself. So you can see that we got, these things are very broad, that you're going to, so more than likely it's going to meet the definition of, is this an injury and illness? Then we determine work related. Look at this first bullet. There's a presumption under the standard that if injury and illness is a result from an event or experience at the work environment, then it's work related. Now, that doesn't mean you can't show that it wasn't work related. You can have things that happen at work that are not work related. So, you're just going to have to jump through more hoops and have to kind of dig in more to know exactly what happened. So you got to, a case is presumed work related if and only if the event exposure at the work is the discernible cause of the injury or illness, or significant, look at this one, or of a significant aggravation to a pre-existing condition. Once again, we got these very broad definitions for the main purpose of including recordability. That's, so. The work environment, basically any place where the employee is working or is present, so as a condition of employment. So nothing hard about that. There are exceptions. If you're at a workplace and you're a member of the general public, you're not first of all, you're not an employee, you're the general public, and so it's not going to be work related. If the symptoms arise in a work environment just by whatever, but are solely due to non-work related events or exposures, then it's not work related. And then if you voluntary participation in wellness program, medical, fitness, or recreation, and you get injured, that is not considered work related. So once again, man. Come on, yeah. Other exceptions to working, eating, drinking, or preparing food or drink for personal consumption, and you can somehow get injured or illness, food poisoning, whatever. No, not work related. Personal tasks outside assigned work areas. And we'll talk a little bit about that in a minute, but this personal grooming stuff outside of work, usually you're just not gonna, it's not gonna be right. But if you're doing, or personal tasks outside of it, you're gonna have it. But you have to, that's why it's important. You're gonna have to really dig in to figure out what exactly is what actually happened here. What were they doing? Personal grooming, self-medication for non-work related conditions, or potentially self-inflicted injuries or injury. That's gonna be an injury. That's not work related. Motor vehicle accidents in the parking lot, access roads during commute is not considered work related. But you got to understand the here's the test though. You would say, well, that makes sense. That last bullet, you would say that makes a lot of sense. Okay, but it's not that simple. If you once you pull into the parking lot of your company's parking lot, and as soon as you park and step out of your car, and say you get there, it snowed that day, there's ice and snow, you park in the parking lot, the company parking lot, and you open the door, step out, and slip and fall and hurt, twist your knee or whatever, have to go to the hospital. That is work related. If you're driving around the car, if you're driving along the parking lot, and you're looking for a parking space, and you see a parking space on the next row over, and so you speed up to get down to the end of the thing, turn around and come back. But you know what? Joe's things saw the same, but he's on the next row over. He sees it too, so he speeds up, and you all both turn in there, and you end up having a car accident because you're both turning into the lane where the space was. That's not work related, okay? But now, if you're going in the park, if you go into a public parking lot. Now, this is kind of question here. If you say that the company doesn't have a parking lot at its building, or only have a few spaces, but across the street is a public city-run parking lot. So once you park there, if you got out and say it had been snowing and there was you get out and you slip and you twist your ankle there, that is not work related. Only once you got on the property would it be work related. So you need to understand that too. So anyway, so we want to make sure we get those covered. All right, let's keep going there. If you get the common cold or flu, then that's not considered work related, even if you caught it from at work. During COVID, at first they started at COVID. OSHA was thinking, well, it's probably not work related because they didn't know much about COVID, and so they didn't know exactly. They thought it was like the flu. And just for one example, eventually it didn't take them too long where they said if you got COVID because of your someone in your workplace, then that would be work related. So also mental illness, it's basically considered as an exception. It's not work related. So a little hard to get. That's pretty easy to understand, I think. But anyway, I keep seeing these. It must be a computer thing. So working at home. OSHA tries to stay way far away from this. Okay, they don't want to get caught up into that at all. But sometimes they do. But if you're at home working, and that's happening now, we got a lot more people working at home than they ever had before. And you're getting paid, you're performing work for pay and compensation, and somehow you get, you're working at your home office desk, and you get up and you get your computer wires underneath the desk. You get caught up in your leg, and you get up and you fall down, and twist something, that would be considered work related. Now, if you at home working, but you get up to walk to go get some water or something, and you step on your 3-year-old daughter's doll and you twist your ankle, that would not be considered work related. So that's why it's very important. You got to ask the question. When somebody says, "Well, I got hurt at home," well, I'm sorry to hear that. What exactly happened? Can you give me a description? What were you doing before it happened? What happened? What were you doing when it happened? So to get the whole information there, because it really is important that it could be coming there. If there's a medical opinion regarding the resolution of the case, then you must follow the doctor's opinion. Okay, so if exposure triggered the reoccurrence, it is a new case, something like asthma or rashes. But if the symptoms reoccur in the absence of some type of exposure, sites like silicosis, tuberculosis, asbestosis, that's not work related. So it's not, and it's not. Well, it could be work related, but it's not a new case. So you'd have to kind of go back to where it was initially, assuming that all that stuff occurred. You got that silicosis or tuberculosis from the work originally. So, all right. So injury. Now these are the general recording criteria. Remember, it said all those things that we had to do. So injury and illness is recordable if it resulted in one or more of the things. If the death, the injury result, the work related. Remember, once again, we got work related injury caused the death. The work related incident caused the person to be days away from work, or restricted work, or transferred to another job. All those would make it recordable on the 300 logs. Also, if it's medical treatment beyond first aid, and we'll talk about that a little bit more in a second. If you lose consciousness at the office, and somehow if it's work related, that's going to go on the log too. And if it's a significant illness or injury or illness diagnosed by a healthcare professional, that's probably going to be on the log too. It kind of, once again, it depends on the circumstances. So it's very critical that when you're investigating it, you get all the information so you know what it does and what it is. I don't know where this came from. Does injury days away from work or days restricted? So when you have days away from work or days that you're restricting, in other words, you can't do your normal job, then you count the number of calendar days employees unable to work, including weekend days and holidays and vacations. This was a change back in 2016. Before it was they didn't count weekends and they didn't count holidays and they didn't count vacations. So now look at this next bullet. When they made that change and added all these other days, they capped it out at 180 days. But unfortunately for employers, it's not too often that somebody's out 180 days. It just doesn't work. It doesn't. Some it does, but you have to have some type of serious injury. So you end up your injury, your numbers, your days away from work or restricted work numbers are much higher now than they used to be. You can stop counting if the employee leaves the company for a reason unrelated to the injury or illness. And you can stop counting if there's a medical opinion exists and you're required to follow it. So if the doctor says, gives your guy a note that says you can return, this is like on Thursday, it says you can return on Monday. Well, that would be, if you don't count the first day on Thursday, but you count Friday, Saturday, Sunday, Monday. So that would have been 4 weeks. Well, they're back, so it'd be 3. But if the doctor says you can return in 3 days, you can come back on Monday, but the person doesn't come back till Wednesday, you still have 3 days. You don't count Tuesday or Wednesday, you don't count Monday or Tuesday because he came back. The doctor said he could come back Monday, so that's when it stopped on Monday, even though he didn't come back until Wednesday. So you need to be remembering that. That's important too. All right, restricted work case. A lot of people don't understand exactly what is a restricted work case. Well, it's unable to work the full day he or she would have otherwise been scheduled to work, or unable to perform one or more routine job functions. Now look at that next bullet. An employer's routine job functions are those activities the employer regularly performs at least once per week. Once again, it's real broad, so we need to be aware of that kind of stuff. We need to be focusing on that there. So, not recordable as restricted work if the employee just experiences minor muscle discomfort. Once again, that's what I'm saying. You got to ask, you got to dig deep into the reasons why. Well, okay, you say you're hurt. Is it just, tell me what you're experiencing? Well, I pulled my back a little bit. I got some minor muscular discomfort. Well, okay, that's not reportable. It says, yeah, I pulled my back and I'm really, I can't move and all this other stuff. Well, that's going to be recordable. If a healthcare determines that the employee is fully able to perform all of his or her routine job functions, that and what happens here is you get a note from the doctor that says Joe is able to return to work on Monday. Well, if he doesn't return to work until Wednesday, that doesn't matter because he was able to return to work according to his doctor, even though he's feeling bad. I don't care. The doctor says he could come back on Monday. That's when you cut it off. So there. And if you're signing work restrictions to prevent someone from getting more seriously injured, serious condition from developing, that's not considered restricted work, and therefore you wouldn't count those number of days. Get over this. It's amazing. Come on. All right. First date. All right. This is very important. Remember I said first aid is a limited number of things. Everything else is medical treatment. If it's medical treatment, it's recordable. If it's first aid, it doesn't go on the log. Okay. So removing splinters or foreign materials from the area by irrigation treatment, first aid. Finger guards, first aid. Massages, first aid. Now, first aid. Active release techniques is it considered first aid? There's an interpretive letter on that. There was some real big question about whether or not it was really if it was involved in massages now or physical therapy. There's a distinction between massages, which is first aid, versus physical therapy, which is medical treatment. So you need it. Once again, you're going to be asking the questions. Well, what did happen? Well, they sent me over here and I got a massage. Okay. All right. Well, what did they or I got physical. They told me I was getting physical therapy. But what exactly did they do? Well, they just massaged my back a little bit. Well, then it's not work related. Okay. It's first aid. Excuse me. It's first aid, therefore not work, not recordable. Drinking fluids for release of heat stress. Once again, first aid. I hate this. I didn't know this. I don't know because I didn't see when they said it's work related. It's always recorded if it's a cancer, chronic irreversible disease, bone fracture, ear puncture. All those are going to go on the 300 logs on first aid. Bloodborne pathogens. If you get a needle stick, more than likely that's going to go on the logs. They're going to be considered that. So you need to be a little bit careful about that there. But we're going to probably record all work-related needle sticks there. Splashes. You got to see what actually happened to be able to make that determination. Medical removal. As I said, if it's removed for medical reasons, then you record from the next day after he's removed from work for medical removal, the day or start away from work or restricted work activity. So you have these two times that you have to record, but you don't start the day it happens. If Joe gets injured and he's put on restricted work, or then you start counting the next day, and then count to when he comes back till he comes back. If the case involves voluntary removal, once again, we're not going to record those things. And most of the time, when things are voluntary, you're not going to hear it. Hearing loss. If you have you must record work-related hearing loss. And once again, this is going to be a little bit difficult. You're going to have to see that. But if you're going to, for a standard threshold shift, that's hard to say. If it experiences a standard threshold shift, you're going to more than likely have to have a hearing conservation program in place. So that means that the noise level is above 85 decibels. So you need to look at those things too, exactly what happened. And then you're going to have your baseline, and which will give you where he was when he first started. And then the most recent audiogram determines if you've had a shift. And this is the shift, it's the 10%, 10 B or more shift at the 2000, 3000, 4000 hertz in one or both ears. So if you had that, then you would have a recordable incident here, a recordable incident. So let's see what else here. We talked about the baselines there. There is a chart in the hearing conservation standard that does adjust the hearing loss based on the age. So and whether a standard threshold shift has occurred. So if you have the shift based from the baseline and then the most current audiogram, then you need to look at how old that employee is and go to the chart to see, has he actually made the standard shift of 10%. So that's pretty much that's most people don't know about the chart, but it's in the hearing conservation standard. You got tuberculosis. If somebody got tuberculosis at work, it's probably going to go there. So if the person is being exposed, it's not recordable if the worker is living in a household with a person with diagnosed with active TB. The health department has identified the worker as has contact with the individual with active TB, or a medical investigation shows the employee's infection was caused by exposure away from work. So once again, we got to ask a lot of questions when we're trying to determine. So I think that's where a lot of employers fall down on when it comes to record keeping. They try to do it simple, and it's not simple. That's why a lot of these large companies, Fortune 500 companies, get these things wrong. They're not taking the time to get all the answers that they should be. And once again, I told you, if you get the answer, if you're recording things you shouldn't be recording, that's hurting you as a company. Here's the 300 log. And it's pretty straightforward. This first line, you can do 1, 2, 3, 4, 5 if you want to do A, B, C, D, E, whatever. Then the name of employee, his job title, date of injury, where the incident occurred, and that's very important. But number F, this is really important. You got to look at it. It says it describe injury or illness, part of body affected, and what was the direct injury was made. How did it get hurt? And here are their examples: 2nd-degree burns on the right forearm from a acetylene torch. OSHA looks at this and cites employers a lot of times on this one because they put down, cut to hand. Well, they even put down what hand, and then tell how. So you need to make sure you put that down because OSHA looks at that first thing. Then if there's a next one, G, if you have a fatality, you're going to check that box. If it's and you check them, you only check each one of these, all these H, G, H, I, J. You're only checking one of those. Okay. So if it's not a death, the result from days away from work. If it was yes, check that. If not, no. Okay. There was a job transfer restrictions. Yes. If you haven't already checked one G or H, and it is one, then I, then you'll check I. If you don't check I, then you check J for sure. Okay, that's the catch-all. Now the next category is here, K and L. Okay, days away from work, and the next one, L, lost time, job transfer restriction. You have to put all the days. So you start out with the number of days away from work. If you get to 180 days, you just stop there, and that's it. You're going to have 180 days. If it's 90 days away from work, you're going to put 90 in that first in K. And if you had, and then you had 80 days there, well, 92, 90, so you wouldn't do that. You'd only put down, you got to stop at 180. Well, I guess you would. So if it's 90 here, you could have another 90 here. So it cuts off 180. Then you're going to check one of these boxes here on M, 1, 2, 3, 4, 5. Most of the time you're going to check injury, okay? But you need to look at those carefully. So a lot of employers, for some reason, don't. And you must fill it out. And then, of course, you're going to summarize at the end, or you're going to total each spot at the bottom. And then when you finish totaling it, that's going to go in the 300-day summary. Now, here's the 301s. Most employers don't use this form. They use the first report of injury form from a workers' comp thing. But you need to look and see, make sure that the workers' comp form that you're using has this, have all these questions here. You have that you have the same information requested on that form, your first report of injury form, versus the 301, because you're required to provide all this information. So a lot of there are some states that don't have all this information on the first report of injury form. So just remember that. So, all right. And then we go to 300 days. Now, you remember we talked about GHIJ? Well, that's from the 300 logs. This is where you get to, you total the numbers up at the end of the year. And that's where you put each one, total number of deaths, total number of restricted days away from work, total number of restricted transfers to job restriction, total number of others. So that's where you get this information. Total number of days away from work, you put that number in, a total of days transferred, and then you put the number of injuries. That's that far column there, M. These are all the different skin disorders, respiratory conditions, poisoning, hearing loss, all that. You put the numbers in there after you total them all up. Now going over here, this is the point. You're going to have the facility's name. Now, once again, if you have any, and I'm sure I have it here somewhere. If you have a work site that only is in operation for less than a year, you can combine that with another site. Okay. Well, once it goes over a year, it has to have its own 300 logs and 300-day summaries. All right. So you're going to put the name of you're going to put here, you're going to put the date, year. Then you're going to put the facility thing, address, industry description, what that is. You're going to go to your NACE code. It's not. This is the old one. Now use the NACE codes. Excuse me. Here's the NACE codes right down here. I'm sorry. It used to be you only had this one. Then they added NACE, but now you pretty much everybody uses NACE codes. So you need to know what your NACE number is. Average number of employees they had at the site, total number of hours worked. Now this last thing is very important. This is where you're certifying. I certainly have examined this document and it's best of my knowledge. And the entries are true, accurate, and complete. Company executives. The safety director normally is not a company executive there, or the safety person cannot sign this. Usually the person that can sign this is the owner of the company, the officer in the company, the highest ranking management person at the site, or the supervisor of the highest management person at the site. Those are the 4 people that can sign this. Nobody else can sign it. And if you have somebody else sign it, then you could get a citation for that. All right. We have to file. We put on any work-related injury or illness has to be put on the form 300 log by within 7 days. All right. And okay, let's see. Yeah. Okay, I don't know where this is, but privacy cases. This is something you don't see too much, but if you have a case with one of these things here in the body part sexual assault, then you don't on that thing where it said name of employee on 300 logs, you just put privacy case, and you keep a separate list of those numbers. That's names on the number it corresponds to in a private file locked up someplace. All right. Okay, I'll get to needle sticks, voluntary request. Somebody asks you not to put their name on the form, you got to honor that request. Okay, we won't. You have sometimes you have to go there. So, we talked about, like I say, you have to have a 300 log for each establishment. And I said, if it's less than 1 year, this is mostly construction sites, which are less than 1 year. Normally, if you have a bunch of construction sites that the project's finished less than a year, it's going to go on the home log of the company. So, but you have to have one person connected to the to each log. Every employee has to be tied to some establishment. Is what I guess the guy said there. If OSHA asks you for it, that you have to provide it within 4 hours. If somebody else asks you, the former employee, personal or authorized union representative, you have to provide that within the next business days for 300, 301s, and The unions they can only get it within 7 days, so you do have some leeway there. Let's see. I think we haven't done that. I've already talked about this. Fatalities, you have to report within 8 hours. Hospitalization, amputation, loss of life within 24 hours. You do not need to report highway or public street motor vehicle accidents outside a construction zone. If it's in the construction zone, that it is reportable or recordable on the or reportable to OSHA. You do not have to report do not need to report commercial airplane, train, subways, or bus accidents. Okay. I'm sorry about this. Oh, we knew this. We finally got to this. So, all right, Jason, I guess we got to it and we got some time to be able to answer any questions if anybody has any. So,
Yep, no, absolutely. Now we have quite a few questions here for you. So let me just go through each one here one by one.
are you paying me by the question? I can't remember. I forgot how that
I
went.
think it is actually.
Yeah. But look at that. But I would direct everybody to this. Remember, bad decisions make good stories and usually make the evening news. So just always remember that.
I like that. I like that a lot. Good stuff. All right. So question one. If an HR director is overseeing all the OSHA incidents, they wouldn't be able to sign the 300A?
No, it's the record keeping standard lists the 4 people that can sign it. Owner of the company, officer of the company, the highest ranking person at the facility, or the supervisor of the highest ranking person of the facility. So that's the 4 people. I get this a lot. When I get those logs, when I get the 300-day summaries, when OSHA's asked for them, and before I let the OSHA company send it to them, I tell them, you need to go get somebody else to sign this. You can keep it as it is, but you need to have someone sign it so that make one of these 4 people sign it.
Next here. If somebody is in a training session on the clock and gets hurt on the break, is that a recordable?
Yes. Well, once a minute, if it meets all the other requirements, but yes. The fact that he's on a break does nothing. So the fact that he's on a break at working it doesn't matter. And work related could be there's case law out there where a person's walking down the hallway and sneezes and his leg goes out. That's work related.
Let's see here. Quite a few more. If an employee is hospitalized for surgery that's following an injury, but not at the time of the injury, does OSHA have to be notified within 24 hours?
Hold on. I gotta think about it. I gotta. I'm just gonna read it. I'm gonna read what the thing is. This is. It's okay. Here it is. What if the fatality, inpatient hospitalization, amputation, or loss of eye does not occur during or right after the work-related incident? You must only report a fatality to OSHA if the fatality occurs within 30 days of the work-related incident. For an inpatient hospitalization, amputation, or loss of an eye, you must only report the event to OSHA if it occurs within 24 hours of the work-related incident. However, the fatality, inpatient hospitalization, amputation, loss of eye must be reported on their 300 logs. That's your answer.
Gotcha. So if someone has to have surgery, let's say a week after that injury that was already put on the 300-day log, that they do not need to notify OSHA within 24 hours.
Right. If we don't have if we find out that or it's not, something happens that he has the accident occurs, the work-related incident occurs, but for some reason at the time he wasn't needed to be hospitalized, but then a couple days later, 3 days later, he has to be he's hospitalized because of that. Then the answer is no, you don't. there's some thought that maybe something intervening may have occurred there, I think.
Okay. More questions are coming through. If we have been recording first aid incidences in our log, should we go back and remove them from our 2023 log, or just stop recording them going forward?
Well, if they're not recordable, you can line through them. You can go through your logs, you can go back 5 years. Technically, you're supposed to go back 5 years. But yeah, you can line through them. And then of course, if OSHA, if something comes up and OSHA wants to see your logs, you're going to have to explain, well, this, we had this, we thought we were recording first aid injuries, and we didn't know we didn't have to. So that's why we lined them out. But then again, that changes the numbers on the 300-day summaries, which is a good thing. Just remember that.
The next is, our drug-free workplace policy says to drug screen after all injuries. Why would it be retaliation to drug test?
If you're doing all injuries, no exceptions, and I think that would be okay. It's only when you're, well, let me ask you this. I think you could probably argue that point, but if you don't drug test somebody doesn't have an injury, but they have a car accident, or an accident with a vehicle, company vehicle, whatever, or has something else, then I think that was where they start saying you're picking and choosing. But if you're saying all injuries have to be or drug tested, I think that probably would be okay.
Next question. We have offices in different locations, but have always reported on 1-300 and 300A. Do we need to break these out by different offices and have a 300 and 300A for each location?
Yes. Unless you can show somehow, well, once again, I'm assuming that the other offices are they've been there for over a year. And so you have that. And they're not in, you don't have one office on one block, and the next block over you have the other office. You might be able to argue it, and you have management running both establishments. You might be able to argue that you could do just one log on those two. But if you got a bunch of offices and they're like miles apart, or even a mile apart, they have to have their own separate log. Yes, so you need to pull it all out. So in a way that helps you, because it gives you it reduces, well, it could help reduce your lost time injury and illness rates and your DART rates, but it just depends. Could be a positive, but maybe a negative. But the answer is yes. You have to have every establishment. You have to have a log and a 300-day summary for every establishment, and so.
Okay, so every location then has to have that. If they have 3 offices, 5 offices, each office location has to have their own 300.
Yeah, 10 miles. These are 10 miles apart. They're each separate establishments, and they have to have their own logs.
Next question here is, I am with a nonprofit that has 2 mobile units that provide services. Are these considered physical locations?
Can you read that again?
I am with a nonprofit that has 2 mobile units that provide services. Are these considered physical locations?
Well, that's a good question. I've never had that asked of me. I would say this:
too, yeah.
If you park the 2 mobile units are parked at one place, your headquarters, then I would say you only have one establishment, that they're all tied into the establishment. And those employees would be tied into that one establishment.
So if it was parked in on the property of the business?
I'm saying, yeah, well, they return there every night after they go out and do, they're they're doing blood collection, and they go from place to place to place. If both of them and the people that work in those are based at their headquarters, they come and they park their car, they come to the parking lot and park there, and then they drive those buses or whatever out. I would say that's just one facility.
Quite a few.
That's the home base. It's kind of like just like Comcast. They're traveling all over the place. They got trucks going they got hundreds of trucks, but they all come home. Well, sometimes they keep it at their houses, but for the most part, they're based at one headquarters, one district office. So that's their establishment, and everything goes on that log for that establishment, even though they're not working there, they're working out on the road.
Next question is, if someone is driving into work and gets into a car accident, would that apply as an OSHA incident, or if they're driving home from an appointment?
And they get injured? I'm assuming that means they got injured.
It's only if there was an injury, not an actual accident. Or I guess the question is, would that apply as an OSHA incident? Is that if someone was driving into work and gets into a car?
Here's the test. If you're driving in the morning and coming to work and you get in an accident, that is not work related. Now, if you're driving for work, okay, you're a salesperson, and you're the Titleist. I guess I think Titleist is here in Atlanta. You're the Titleist sales rep, and you're going to the Masters to set up the booth, the Titleist booth, and you're driving there on your way. And as you drive there, right before you get to Augusta, you see this exit sign that says the Laurel and Hardy Museum, which is true. It's 2 exits before you get to Augusta. You say, I love Laurel and Hardy. I'm going to get off here and I'm going to go see the Laurel and Hardy Museum. And you get off, you're so excited, you get off the exit there, you get to the top, there's a blinking stoplight, you're so excited, you just pull out without really stopping and you get hit and you get injured. You've deviated from your work, so you're not doing work, okay? You're not doing work. So that would not be recordable. Now, Joe, the Titleist salesman, sees the Laurel and Hardy, says, I love Laurel and Hardy. I'm going to go stop. I'm going to go back to see that after the tournament's over. And he goes to the 2 exits up, gets off at the Augusta Nationals exit, gets up. He's excited now because now he's going to be seeing all the big golfers. And he doesn't stop completely and gets at the top of the light and turns and gets hit and is injured. That would be work related because he is doing what he's supposed to do as part of his job. But if you take a personal detour, that stops the coverage. But here he didn't take a personal detour. He got hit. So that would be recordable stuff. Now, same thing when Joe, Titleist salesman, he gets to the hotel. Once he gets to the hotel and checks in, he is no longer on company work. And so if he got injured walking around the hotel or whatever, that would not be recordable. So there's some, you have to kind of look at each case. Once again, that's why I said you got to ask questions as to what happened, what exactly happened. And so, yeah, I think that answers the question.
And then there's another question that's somewhat on the similar side is, can you revisit the not reporting a highway or public street accident?
Yeah, if you're on a public highway, OSHA doesn't, that's not reportable, okay? It still may be recordable, but it's not reportable. In other words, you don't have to call OSHA.
I got a couple more here that just came in. If if someone has a seizure, falls and splits their head open while working, would that be considered and it's a
Work
reportable
related,
work-related incident?
a recordable. Would it be recordable?
A recordable and
Yeah. Well, here you're going to have to kind of get some information. If it's a stroke, OSHA this says doesn't consider that to be work related. Okay. However, it's a heart attack, and there's a specific section here. Where is it? Hold on. Let's see if I got it marked. Hold on, dude.
Very good questions.
Yeah, they are.
Participants here, so very good.
For the heart, there's a section that talks about heart attacks. If it's a heart attack, OSHA takes the position that it may be work related, and therefore you have to treat it and call in. This is on reporting as a recorder. It's still going to be if the person it's more concerned about whether you got to call OSHA or not. If somebody has a heart attack or even a stroke, you have to look and see what's happening at the time. Like I say, OSHA takes a position you don't have to recall in strokes. OSHA takes a position that if it's a heart attack, you have to call it in, and they'll make the determination if it is. Now, I've taken a position several times. I had a K1 case where an employee was in the office, and he went to an office meeting, a conference meeting in the office there, and it was late in the afternoon, and it finished up, I think, about 5:36, and he told the guy sitting next to him, he says, I just don't feel really good. I said, I'm going to go back to my office and just relax for a few minutes and then head home. Well, so he goes, and he's found by the cleaning service dead over on top of slumped over his desk. OSHA was saying that we should have contacted them because it was found out he had a heart attack. I took the position, well, yes, but you have to show that there was something. He was just sitting at his desk. He wasn't doing anything extraneous or anything that could have caused the heart attack. And therefore, this was not work related. Now, my client got cited for that, but once I got before the lawyers, they dropped it quickly because it was clear. You have to be able to OSHA has to be able to show that, if it's a heart attack, that he was doing something strenuous more than his normal job that caused the heart attack, and therefore but if it's, like I say, with respect to calling OSHA and telling them about it, then you have to, if it's a heart attack, OSHA takes a position you're supposed to call them in. I take the position that, well, we got to look at the facts here. If there's no way that nothing at the job caused him to have the heart attack, then it's not work related. But if you want to be on the safe side, just call it in, and just when you call it in, just tell him, well, he was saying he wasn't feeling good. He went back to the office, he's sitting at his desk, and he had the heart attack. No, and they're going to say, well, he wasn't doing anything strenuous, so therefore it's not work related, so we're not going to bother you.
So would that fall under the same thing if someone were to suffer a seizure and they fell and split their head open?
Well, a seizure, yeah. Well, it could, well, you still would, even if on a heart attack, you would still, it's not considered work related. You have to do that. Here, the question was, if he has a seizure, I think that's more like a stroke. Strokes and seizures is I think, basically the same. So I would say that would not be work related, so it wouldn't be recordable. If it's not work related, it's not reportable.
So that
You
would
got to
not
go.
be
You got to always go through the analysis, one step at a time. Is it work related? Is it a new case? Does it meet all these other criteria? And then that's how you do these things. But I think if you have a seizure, they would consider that as a stroke, and so therefore, I guess you could have other type of seizure, but I think our position would be that this is like a stroke and therefore not work related.
And then another question that's kind of very similar to that is if an employee has a condition that is not caused by work, but they fall or injure themselves while they are at work as a result of that condition or that illness, is that still considered work-related injury, and is it reportable?
Yeah, these are really good questions. I think
Yes.
I think the read that again. So
Sure. Yep. If an employee has a condition that is not caused by work, I'm assuming that it's a precondition, a pre-medical condition, but they fall
right.
or injure themselves while they're at work, and as a result of that condition or that illness, would that still be considered a work-related injury, and would it be reportable?
Yeah, well, I'm thinking that it's the last what we just talked the last one. I would say that if it's some type of seizure, some type of pre-existing illness that is not work related, then it's not work related. That caused it. What was the work relatedness here? Well, there's none, because you're saying, well, you got hurt at work. Well, yeah, okay, but here, if we know that was something, it's now if we didn't know it, he's walking down the street or walking down the hallway, and all of a sudden his knee gives out. OSHA still considers that to be work related. But OSHA is going to look. The question is going to be: did something aggravate that cause him to fall or whatever? So that's once again we got to start asking him a lot of questions, because we got to make sure we know how to do that. But I think you can argue there that, okay, what is this? What caused this was a some type of thing that was not work related, which is a little different it's a little hard to understand. But if somebody's walking down the hallway and he sneezes and his foot goes out, he doesn't even have to sneeze. His leg goes out. OSHA takes a position that's and gets hurt, that would be work related. Now here, I think we can argue. Now he had something. You show me that what caused the fall was this condition, which was not connected to the work, and there was nothing that aggravated it or caused it to reoccur, and therefore, which we don't consider this to be work related.
Next is
that's a close one. That's a real close one, though.
Yeah, kind of like a case.
That's how I would argue it. I would argue that way. So.
Next up is, can you speak a little more on the OSHA's 6-month citation insurance rule or issuance rule? Excuse me.
Issuance rule, yes. Under the Act, OSHA is required has to issue any citations within 6 months of the start of an inspection. So it's very important when your OSHA shows up at your door that you have someone you're taking really good notes on stuff. And there's a whole series thing, and particularly now, it's even more critically important. But yes, so the 6 months starts when OSHA shows up at your door and starts the inspection, because at that point in time they either could, or with the exercise of reasonable diligence, could have found the hazard. Now, there is some exceptions. I mean, there's other exceptions that kind of expand that 6 months. If you're hiding stuff from OSHA so they don't find about that hazard, then they can argue that it should be stayed during that time period. But generally, and this is pretty much 99% of the time, OSHA will document when they start the inspection, and they'll go 6 months out, and then they have to issue the citations. If they miss this if they miss the 6 months, then they can't issue citations. Well, they can issue citations, but now the catches here, and I get this a lot, especially in the last year or so. You have to look, when you get the citations, you have to look at the issuance date, because it could be I've had 3 weeks from the issuance date to the time the company actually got the citations. And the case law says that as long as OSHA has issued it within the 6 months, then it's a valid thing. Of course, you could delve into why didn't we get that? You all hand delivered them. Why didn't you hand deliver them? Within the 6 months.
Mhm.
And but usually that's not a problem unless there's a fatality. Fatalities they have to jump through a lot of hoops, and they have to get approval from at least a regional administrator. But a lot of times now, depending on the severity of the case, they have to go to the Washington national office in Washington D.C. get the final sign off before they issue the citations. And as if you have that situation, you're going to a lot of times I'm getting the citations hand delivered to the company on the day of the last day.
Next question. If an employee normally works Monday through Thursday and has worker comp injury appointment on Thursday and is released to work on Monday, is Friday, Saturday, Sunday lost time since they are not normally scheduled to work on those days?
Doesn't matter. The answer is yes. They're lost time.
Even if they're
That was the
scheduled
rule
to
that got changed. That's the rule that got changed back in 2016. So yes, you count every day. You don't count the first day that they're lost time. You start the next day, and then you stop when they come back. Now, if they got a doctor's note, it doesn't matter. I mean, they didn't get the doctor's note before that, so but it wouldn't matter if the doctor's note says you can return to work on Monday, then that's the date you use.
And weekends fall into that as well. So if it's a Saturday, Sunday, they don't normally work on a Saturday.
Holidays, vacation days,
That's all considered lost time.
weekends, all that is counted. Those are days, and this is the days they count. There's no days they don't count, I guess is what I'm saying.
Yep. Okay. Next question is, what if you have one employee and he works from home, but is the only employee at that site? Does that person need to keep a 300 log?
Um, the answer is yes. I mean, but no, what you're doing is yeah. Let me give all the things you have to show. All right, I'm assuming this employee is working more than a year. Okay, so he has his own establishment, and were they saying that he does work from a place, but he's now working at home?
It says, what if you have one employee and he works from home, but is the only employee at that site? Does that person need to keep a 300 log?
You're required to keep a 300 log for every establishment, and if you only have one employee, that's okay. I mean,
Mhm.
I'm assuming you have more employees than 10, because you do have the exemption for 10 or less employees from doing the 300 logs. So, but if you have, because that's company wide, so if you have more than 10 employees, yeah, the answer would be yes.
And if it's less than 10, then no.
If you have less than 10 employees company wide, that includes secretaries, managers, CEOs, CFOs, then if it's less than 10, then you don't have to do the 300 logs.
Yep. More questions are keep rocking in here. I am with a nonprofit in child welfare. If social worker has a car accident while on the field, do we have to report this as an accident or not?
Well, you have to only report it. It would be recordable. It would go on the log, but if it's going to be reportable, you're going to have either fatality, hospitalization, amputation, or loss of an eye. So you don't have to, if a person gets in an accident, is injured but doesn't go to the hospital, or it just goes to the emergency room and is released later on that day, that would not be reportable. but it would still go on the 300 log.
And next question, if an employee has a condition that's not caused by work, oh, I'm sorry, I already read that one. Oh, actually, you should just
I'm
add
still
on there.
charge you for that. So
Yeah, no, that's all right, because,
I don't think you have that much money. I don't know if you got the money to pay here. That's the
no, I don't. I'm gonna have to figure out how to help you out there. But that with that work related thing, right? When they were asking if it's a precondition, right? The condition that they just wrote back, it would be considered epilepsy. Would that need to be
okay.
reportable?
Right. Okay.
Epilepsy.
So you would have that as a pre-existing non-work related medical condition. Yeah. Um, so yeah, that wouldn't be that would not be reportable if you went to the hospital or anything else like that. I mean, you'd have to kind of look at it though to see if it is this does this go on the 300 log since he's at work and everything.
Mhm.
Yeah, and see what the factors are there, but it may be. It's definitely not reportable, but it may be recordable.
Someone wrote, we're not violating any HIPAA laws by asking all these questions, are we?
HIPAA, you gotta. You're at the zoo. All right, is that it?
Nope, got another. Is self-cleaning and bandaging of a laceration or puncture and declining to go to the doctor considered first aid or medical care? That's a good question.
Well, hold on, I gotta get.
And I could repeat the question too.
No, I'm just looking at. Okay.
Oh, yeah,
Um,
self-cleaning and
I-
bandaging of a laceration or puncture and declining to go to the doctor considered first aid or medical care.
okay. Okay, using. Yeah, I think one of the couple of things dropped off on that first aid slide. Um, let me kind of go over what's on there. The one that's dealing with is using wound coverage such as bandages, band-aids, gauze pads, or using butterfly bandages or steri strips. Would consider our first aid. Other wound closing devices such as sutures, staples are considered medical treatment. So this would just be first aid. Also, first aid is using non-prescription medication at non-prescription setting. So if you use Tylenol and use 8, they give them 8 Tylenol. That may put them into medical treatment versus first aid. Administration, tetanus immunization, hepatitis B vaccinations, rabies vaccinations. Excuse me. So administration of tetanus immunization is first aid. Other immunizations, hepatitis B vaccinations, rabies vaccinations are considered medical treatment. Cleaning, flushing, or soaking wound on the surface of the skin is first aid. Hot and cold therapy is first aid. Using any non-rigid method of support, such as elastic bandages, wraps, or non-rigid belts, is first aid. So there's a couple that dropped off. Drilling fingernails or toenails to relieve pressure or draining fluids from blisters, first aid. Using eye patches is first aid. Removing foreign bodies from eye using only irrigation or cotton swab is first aid. Removing splinters or foreign materials from areas other than the eye by irrigation, tweezers, cotton swab is first aid. Using finger guards is first aid. And we said that massages are first aid, but physical therapy or chiropractic treatment are considered medical treatment for record keeping purposes. Drinking fluids for relief of heat stress is first aid. I don't know how some of them dropped off that list. So, okay.
Yeah. And then another question that popped up that's kind of somewhat related to this is if a person declines medical treatment, does that equate to first aid only and make the incident a non-recordable? someone declines the medical treatment, that
Yeah.
does not, or that does equate, excuse me, to first aid only, and does make the incident a non-recordable.
Well, OSHA makes it clear you can't force someone to get medical treatment. Okay.
Yeah.
So I would say, um, the answer, I would say though, it wouldn't be recordable because, um, he hasn't met the criteria of medical treatment. He should have had medical treatment, but he didn't have medical treatment. And no one has ever asked that question before either.
You know, we're getting very, very, very good questions from our participants. We got a couple more here also. Going back to,
You're running out of money pretty quick, I think.
I know we are, or I know, I mean, I am. The going back to that question of multiple offices, right? And you said here, you stated that we need different 300 and 300A logs for each office. Even with
Right.
one management team at one office, do we need just to start with 2023, or do we need to go back and separate each of the 5 years that they've kept?
Well, the technical answer is that you should go back and redo them. So, because let me go back here and do a little bit.
And then here's another very good question that was asked from the same person is that, and then do we also need a log for those offices that have less than 10 employees? Which is a really good question.
10 employee things is company wide.
Company wide, even if they have, okay, so you could have 7 different locations, 5 folks in one location, 7 folks in another,
Right.
50 folks in the other buildings, but being that you have more than 10, doesn't matter how much is distributed, you still have to have the logs, correct?
Right.
Yeah, that's what I thought too. All right. What if a company is entirely remote? That seems unreasonable to require a separate 300 log for every remote employee.
Yeah, all this COVID stuff has really made things thing, but I was just looking for establishments. Hold on, let me.
And then also with the remote, how does that work with workman's comp for remote?
Workers' comp and OSHA are 2 separate things. They don't cross paths.
Let's see, one last here.
Right here, let me give you this here.
Oh, go ahead,
what is the work environment? OSHA defines the work environment as the establishment or other locations where one or more employees are working or present as a condition of their employment. The work environment includes not only physical location, but also the equipment and material used by the employees during the course of his or her work. So, but I think the earlier when we were talking about they had 2, I guess, buses or something. To me, they are all located at one place. Let's see. And here's another one that kind of touches which injuries and illnesses are considered pre-existing conditions. An injury or illness is a pre-existing condition if it resulted solely from a non-work related event or exposure that occurred outside the work environment. Okay.
And I do got one more question, looks like.
Okay, you got it?
What was that, Ed?
Did you have another question?
Oh, yes, I did. Oh, I don't know if you were still reading what you were looking. Yeah. Last question, it shows, is all that first aid, or is it, I guess, kind of trying to understand this question. Is all that the first aid, even if it's performed by a healthcare professional at a clinic? So if, I guess what I'm kind of understanding with that, if someone who was injured and went to a clinic and that they performed health, from a healthcare professional, would that be considered first aid?
OSHA takes, that's what they list as first aid. So if that's what was done, see the problem, then it would still be first aid, not recordable.
Even if they went to a clinic and it was
Yeah.
performed by a healthcare professional.
Well, they don't ever say anything about, whether first aid is who performs the first aid.
Yeah, it's omitted from that. I remember, yeah.
Yeah, so
It's kind of a gray area.
yeah, so you're gonna say that somehow that healthcare professional make that medical treatment. And that is an interesting question.
Mm-hmm. Yep, no, we've
Okay, but then again, look at this. You have administering tetanus immunizations is first aid. Well, more than likely, some type of healthcare professional is the one that's doing that.
Yeah. Well, that makes sense. All right. Well, it looks like that is all the questions that we have. And again, everybody that's participated, thank you so much for those questions. I'm
Yeah, and I
sure.
saw there was a question about they're gonna get the slides and the
Yep.
handouts.
Yep. And we sent the handouts to everybody this morning before the webinar, but we're also going to include it again. Everybody's going to receive this presentation as well as the handouts on Friday. But by the end of the day, Friday, you'll have this presentation and everything that comes with that. So again, thank you all so much.
Yeah. And what are we doing next? We're doing another webinar.
Yep, we're going to be doing two webinars that's coming up. We're just getting the registration pages set up. We're going to do March 13th. It's going to be active shooter and workplace violence and what the employer's legal obligations are going to be. And then we're going to be doing in April some updates when it comes to the OSHA National Emphasis Program and the for heat stress prevention. And what's going to be going on, what the updates are with OSHA and with NIOSH coming up with some standards. So that's going to be very, very important for all of you folks to definitely tune into and join us on our next two webinars. So, and we'll be sending out those emails as well once they're set up for you guys to register. And again, it's free education webinars for that. So, and Ed, thank you so much, for your time today. And I know that everybody definitely learned a lot. I mean, that was fantastic questions, a lot of participation from our attendees. So thank you all. And Ed, again, thank you so much, buddy.
Yep.
I just wish everybody a happy new year and be safe out there and God bless.
Yep. Thank you.
All right. Thanks, Ed. I'll talk to you soon.
All right. Yeah. Thank you.
Got it. Have a good one, guys.